morning, Your Honor. On the regular docket, line 2, Michelle Troconis. She also appears on the pretrial docket, line 3 and 4.
Okay, let's start over.
On the Richard Colangelo for the state first, Your Honor, sorry. On the regular docket, line 2, Michelle Troconis. She also appears in the pretrial dockets, line 3 and 4.
Good morning, Your Honor. Attorney John Schoenhorn representing Ms. Troconis today. I will note for the record that she's being assisted by the Spanish-speaking interpreter.
Which is a change from the other time she's been here.
I believe, I'll just say this, Your Honor, although there may be some hint of cynicism in that statement. Ms. Troconis, her first language is not English, although I can communicate with her in English. I also communicate with her in Spanish, which I speak. And if we're going to do anything more technical than just stand in front of the court and enter pleas or whatnot, I felt it was better for purposes of this case that she have the assistance of an interpreter. She doesn't need every word translated, but I'm suggesting to the court that she does not necessarily follow everything 100%.
And I appreciate counsel's comments on the cynicism. I was just commenting to the record that is a change. There was no cynicism there at all. So if he wants to assume things that I'm thinking, I'll be happy to explain to him what I'm thinking.
Okay, gentlemen, you've had a chance to talk about presence of the interpreter, so let's get down to business.
Yes, sir.
Your Honor, we did file a few motions the other day, but I'm going to note that the motion with regard to the files of prior counsel, I would suggest that's moot. It was my understanding that Mr. Bowman did in fact return the materials to the State's Attorney's Office. I have signed 4 pages of discovery disclosures that have been provided to me today by Mr. Colangelo.
And I will speak for the record, Your Honor, that he has all of the information that I have with regard to the hindering prosecution and tampering with evidence case and the tampering with evidence case. I do not have any of the discovery for the conspiracy to commit murder case yet. When I get it, you will be the first to know.
All right, I just indicate, as is customary, counsel for state and defense cooperate on discovery issues. There's no need for the court to get involved unless there's a dispute. So my strong suggestion is that you gentlemen talk to one another, make sure you've exchanged all the information. If there's a problem, you approach the court, make a motion, I'll hear you.
Don't anticipate any, Your Honor. Thank you. I just don't have it yet.
All right.
That's fine. Since the case has been going on for a while, I'm trying to get up to speed. The sooner the better, but I respect Mr. Colangelo's dual role since he's not here full time anymore.
Okay, I respect you, I respect Mr. Colangelo, I hope you respect me, so everybody respects everybody, so let's move on.
Thank you. So I would ask the court to find that motion is moot. I'll either withdraw it or you can deny it as moot, whichever the court
Okay, I find it moot, you're withdrawing it, we don't even talk about it anymore.
Very good.
Unless it becomes necessary.
Right. I did file a motion to transfer this prosecution, but in discussions in chambers, I'm not prepared to argue that today. So therefore, I'm just going to ask that that just remain, but perhaps we'll discuss it at the next court appearance. There's no rush for that.
All right, that's all, we'll talk about it later.
The last motion that he filed, Your Honor, is a motion to modify conditions of release. He did indicate that he wants to be heard on that. So I will, if Your Honor is prepared, I'll let him address the court and have any follow-up if I have any.
I'll listen to you, counsel.
Thank you, Your Honor. I have filed a 13-paragraph motion setting forth what I believe to be the statutory and constitutional bases for reducing bond. We are not asking for the financial conditions to be reduced, although I note it was a fairly high amount of bail set, cash or surety, that my client's family was able to pay through a bonds company. It is not funds that they would necessarily be able to come up with if they had to pay a cash bail. I note, Your Honor, that although Ms. Troconis is not originally from Connecticut, she did live in Connecticut for 2 years. And yes, she did have ties to the community. She engaged in regular activities in Avon at the, there is a water skiing club there. She was a member there. She herself may still be, I think, but was a competitive water skier, both in North America and in South America. She's living now with her mother here in Connecticut. The trouble is, of course, even Mr. Dulos, when he was placed on house arrest, was allowed to go out every day to work and to go shopping and take care of other sundries. Ms. Troconis has been on strict house arrest without the right to do that. All she can do is meet with her lawyer, go to medical appointments, and go to church. And I submit that based on what we represented and what we presented here, those conditions, if they were ever necessary, are no longer necessary. We ask the court to reduce and do away with the house arrest. We'll concede the condition that she should be restricted to Connecticut, Massachusetts, and New York. We include New York since her daughter goes to school out of state. She usually flies into New York airports, and she shouldn't have to seek permission and get a court order every time her daughter is going to come visit from out of state. Other than that, Your Honor, I'm also requesting that any drug testing that was required, which I don't know why that was required. By statute in the practice book, it specifically states, as I know here, that it can only be ordered if there's a reason to believe that a defendant abuses any kind of substance. There is zero evidence of that in this case, none whatsoever. So it may have been an overzealous probation officer or AIC official who decided to include that, but it's without the likelihood of any kind of medical need or evidence that she ever abused any substance. I ask that particular grounds also be removed. Finally, Your Honor, I'm asking that the ankle monitoring be removed. I have a picture I'd like to show to the court. I'm going to show it to counsel. First, because of her, I guess the structure of her ankle bones, it has caused not only chafing, but it is so tight it has caused bruising. And if necessary, I just think that under these circumstances, it is not necessary. The police have her passport. If there's another passport, expired passport, she's prevented, that would be, if the state would like that to be turned into the court or to my possession, even though it's an expired passport, I'll be happy to do that as well. I know she is a U.S. citizen.
That was a condition. Let me start with the easy one, Your Honor. I don't object to removing the AIC or drug treatment. There is no indication. I honestly was surprised when he told me that was happening. So I have no objection to that, number one.
Okay.
Number two,
I'll order that. That gotta be removed.
I'm going to try and remember there was like 17 of them.
You're alive.
So number two, as far as the passport goes, she was ordered to turn over any and all passports, Your Honor. So technically she is in violation of that condition of her release. We've only gotten her USA or American passport. It's come to my attention today that she has an expired Venezuelan passport that has not been turned over to us. That should be done forthwith to the court here in the clerk's office. That was initially ordered. Her first court appearance when she appeared before Judge Blaui way back when. Because just because it's expired, there's nothing stopping her from going to the consulate and just applying for another passport. So we need that. That was a condition of release that she is in violation of. So now moving on, as far as the tightness of the monitoring goes, she complained about that. I did reach out and speak to probation about it. They indicated that she is wearing or using a sweatband underneath the GPS monitoring or GPS bracelet. They indicate that it is kind of a thick sweatband. It's one of the athletic sweatbands, Your Honor, so it's kind of thicker, so it makes it look like the bracelet is tighter than it really is. And when they loosened it one notch, it was too loose. And it was kind of unwieldy, so they've got it in a situation where they think it's as best they can possibly do. But if she wanted to use a thinner sock or something like that to wear underneath it, cut a sock and put that under the bracelet, they'd be happy to try and accommodate her so that it wouldn't be uncomfortable for her. As far as the condition of the release go, Your Honor, the last conditions were placed on her on January the 8th, so less than a month ago. I haven't heard or seen any arguments from counsel that there are any substantive changes to be made. With that being said, I will address the conditions. The court set them. He said that she's been a resident of Connecticut for 2 years. That's correct. She's lived with Fotis Dulos. She, at some point in time, ended that relationship, but I did hear, Your Honor, that she was having contact with him through a third party. Still trying to confirm that in violation of the conditions of her release. Be that as it may, the water skiing club that she belonged to in Avon is something she belonged to with him. So all of her connections were with Mr. Dulos. So she does not have any connections to Connecticut. So I think that GPS monitoring is appropriate here. House arrest was set by Judge Blowy at the time that she was placed on, this bond was set. At the time, it was something that I urged for because I thought it was appropriate. If Your Honor wants to loosen the house arrest up to allow her 1 day a week with approval to work, I haven't heard that she's working, but to work or to attend to basic needs, I have no objection to that. I would just ask if you are very specific in what she's allowed to do or not allowed to do, so probation doesn't call with, questions on can she do this, can she do that. As far as being out any other states, Your Honor, I believe that Connecticut is probably appropriate. So if you're going to allow her to venture out without permission, I would request that it just be for the state of Connecticut. I don't see what a hardship it is for her to request if her daughter is coming to visit her and she has to go pick her up. When she asked last time, I agreed to it right away. I know that we actually just gave the motion to the court and let the court do it on the papers without objection from the state. So I don't believe that that's going to be a situation that we need to worry about. But I'm worried about her conditions of release, right, Judge? Assuring her appearance in court. She has no ties to Connecticut. She has a passport apparently that's expired that's out there that we didn't know about or don't have. And, the conditions were set and she's been compliant.
Okay, Judge Blowy set the conditions a month ago, is that correct?
Yes, Your Honor, January, so a little less than a month ago.
Okay, you want to say anything else?
Just very briefly, we know nothing about third-party contact, and certainly not anything that, if somebody was trying to contact her, that is not something that I think, especially the suspicion, is anything can be attributed to her, whether or not there was efforts to reach out to her through third parties. It wasn't something that came to her attention. Nobody really even has her phone number, and she's not allowed to leave her house. I also note her mother, who's a psychologist in Florida, has moved up and is living with her. She has a practice, but she's been staying with her up until now because she's not allowed to even go shopping. I would just note, Your Honor, that, I went through the pretrial risk assessment points that the bail commissioner is supposed to use, and in every respect, that it gets reduced. You start with what the charge is, and I know it's a Class B felony, the most serious charge. It's not a Class A. Even murder cases are about $1 million, and so without conditions. So I just think it's
Are you about to argue the bond?
No.
Amount of the bond?
No, what I was going to argue is the amount of money. If the parents posted all their property, if she were to flee, they would lose everything. So I think that's something the court can take into consideration. I know for a fact, I spoke to the bail bondsman. He has secured the entire $2.1 million with property owned by both his parents. Father's a doctor, a cardiologist, and mother is a psychologist. I just note that, the last thing I'll note is that ties to the community does not have to be family living here. She has friends, people have come out in support of her in the area around Farmington. So I just ask the court to take that into consideration.
You look like you want to say something.
No, I'm done.
No, you don't? You don't want to say something? Oh, okay, good. Are we done, gentlemen?
Yes, we are.
All right, Judge Blowy set the conditions about a month ago, so it hasn't been that long. The gentleman seemed to agree that it's no longer necessary to have a condition of substance abuse testing, so I'm going to eliminate that. I'm going to stick with the condition that the defendant hand over her passports, whether expired or unexpired. And if she has them with her, she should do it today. If she doesn't have them with her, she should do it as soon as possible. Insofar as the bracelet's concerned, she can work with the probation department so that the bracelet's comfortable. I don't know the requirements or what she's going to have to do as far as wearing a sock on her wrist or she can work that out with them. I'm not getting involved with that. As far as her house arrest is concerned, I'm going to stick with that. I will give her permission to go to religious services, go to medical appointments, of course to see her lawyer, to go to court. She can go shopping, take care of their daily necessities. She's going to have to inform the probation department. I'm not going to allow her to leave the state of Connecticut. So no, she can't go to New York, can't go to Massachusetts. Relatives come into town, she's going to have a meeting someplace. She cannot leave the state of Connecticut. Let me add another thing. Does she have a job?
She has a business which requires her to go to other businesses to sell designer, I don't know how much, there's a lot of media.
Where is this business located?
It's in her, it's a business, an online order that she did. She's a salesperson.
She works at home.
No, she has to go to various businesses to show samples. It's a fabric business that's a designer fabric. She's a representative of the company. Some of the stuff she designed herself. So she goes into
She
businesses.
sells stuff online, or does she have to go to an office?
No, she has to go personally to go to these locations to both measure, pick colors. She cannot only do it online. May I at least ask her as a half measure that there be a curfew so she can at least be out between, let's say, 9 and 7 p.m., 9 a.m. and 7 p.m. without having to, so that she can take care of all of these matters that we're talking about without her having to ask permission each time she does it.
You want to say anything about that?
I object.
Okay, my answer is no. Insofar as her business is concerned, I don't understand it as well as you do. It sounds like she can handle her business by working online from her home on a computer. So if you have some information regarding why she has to leave the house or something further, I'll listen to it. But it's going to leave the conditions where they are, as I mentioned.
I think I can answer that. I have a report from one of these businesses in the Farmington area that she goes into the business, measures, checks what its colors and all that. She goes in and meets with the owners of various commercial establishments, and they decide what colors. They do not go to her house or her condo. They go.
So she has clients, and she goes to the client's business, takes measurements, consults with them about colors of fabric,
Yes.
all that sort of thing?
Yes, and I have
Okay,
a
well,
statement regarding that.
I'll just indicate, Your Honor, that in the last 6 months, this is the first time hearing about this. Just,
she can supply the information to the probation department. If she has appointments, she can tell probation if they approve of it, it's fine with me. But,
So work-related.
Work, medical treatment, religious services, see her lawyer, she can come to court, and I suppose she can go shopping. She needs to go to
just
grocery
so that
stores.
we can be clear, Your Honor, if she has an approved trip, if you will, she shouldn't deviate from that trip and stop other places.
Yes, I don't know how detailed I should or can get on these things, but she got an appointment, she goes to an appointment, handles her business, then she goes back home. But no side trips. So she's going to be at home, or she's going to be taking care of her business appointment, going to court, going to a lawyer's office, going to a religious service, going to the doctor's office, but no side trips.
I assume she can combine two of those in the same trip.
If they're approved by the probationer, there's no
If you
issue.
want me to get too detailed about this, I'll just say she can stay home, she can't go anyplace.
I'm
It
sorry,
sounds
Your Honor.
like somebody's going to approach me every day and ask me, can she go here, can she go there, can she do this, or that?
I apologize.
And I am not, no, there's no need to apologize. I'm just saying that I'm not gonna micromanage her life. And, maybe the easiest thing to do is just to say she's gotta stay home unless she's coming to court or, going to a lawyer's office. I don't wanna do that, I'm trying to give her some leeway, but let's not push the envelope.
Lastly, Your Honor, I'll note just that the conspiracy case is on the regular docket. We don't have not guilty pleas. I don't know if counsel wants to enter those today.
Not guilty pleas.
We will waive the reading, enter not guilty, jury election on the most recent charge.
And we had discussed,
March 3rd, I think you said?
March 3rd.
Okay, and,
thank you, Your Honor.
okay. What is happening on March 3rd? Let me just say this, gentlemen. I prefer that you take more time rather than less if you need to exchange discovery or do something, rather than just to come here.
No, actually, what was contemplated, Your Honor, is that we try and address counsel's motion. I'm hoping that we could have a response done to that in 3 weeks, so that should allow us to be able to do it on the 3rd.
Okay. All right, anything else?
Nothing at this time, Your Honor.
All right, thank you, March 3rd.
Thank you, Your Honor.